Fast forward, any come our channel your social networks say how say GH Politics Avenue. Political stories are training because make headlines. And your general any be Akroma or how need me young block say and the AD can. Best also be to subscribe to the channel. Hit on notification bell, share na for front so answer into me and Kpebu. And need me young block say say oh abus your kunum dada memo akwaba. Afina o banswa. Mr. Say ubiti subscribe to the channel. Hit on notification bell, share na for front so answer into me and Kpebu. And need man a yan wajja comment under the comment section constructively. Na atimi aboa amadwumadi no aye very interactive. At this point in time, we do a year suspended Chief Justice Torkonoo asweye na the ebe nyina no kse na enka ni plead nyina ni se enka all serve a suspension no nenka uguso one officer enka odi ni juma as Chief Justice kopem tama enka asemono Echoas court betimi atranse na umetimi abua asemono na afi Mahama aten ho asese sisi ade ya reinstate no obe carry out the duties fully and now see bia abua bono se onko fi na onko gina home lawyer Martin Kpebu and so atranse semin wo twintwemu ho behia semino mi no betimi ahwe yeko any day ba na ya jemu ntiase yi pa but as so wajemre ewa
on this. I don't intend to spend.
Yes, let me. You see, this CJ matter. I think my brothers have spoken, but let me bring this perspective. There was a petition.
I beg you. I want the question answered.
Okay.
Before you go on. Otherwise, Martin Kpebu, you have given him a question to answer, and he spent time talking about other things. You were asking whether. The CJ had said that by her suspension, she had been virtually sacked. Effectively sacked. Okay. Mm-hmm. And then I was thinking you wanted Martin to speak to it, whether that is true.
I will.
Or not. That is very important. Whether she can remain as a Chief Justice to oversee her own, trial. But that's what he has said.
He said that she's not coming back.
No, he said that in the last part of the conversation.
Unless she wins the case. No, she can't come back.
Can she be the Chief Justice? Because you said that
she can't come back.
He answered that in a form.
So don't worry, let's repeat to be clearer. What I'm saying is that if we can get a settlement that she should resign, exit, go. Okay. Yes, I'm in support of that so we can reduce the litigation because it's embarrassing us, right? Mm-hmm. But if she's not willing to take a resignation, it wants to be led back to act to continue as Chief Justice. No, that one is not possible.
Thank you.
It's not possible.
Please.
Yes. So let me say this. Sometime last year, late last year, Professor Azar brought a petition for the removal of the CJ. Yeah. That petition was acted upon and determined. Yeah. What did the president do? The president made the prima facie determination. President Nana Akuffo made the prima facie determination on the petition, and on the 6th day of January this year, not last year, just this year, this 2025, one of his last acts in office as the head of state of this country, actioned that petition and said it was unmeritorious.
Yeah.
So let's bring this matter into perspective. The suspended CJ, as she is now, never applied for a copy of that petition. Not to my knowledge. She didn't go public about it. She didn't file any process. She didn't say that she needed to be heard before the president made the prima facie determination. So let me ask, was she aware that the prima facie determination will favor her? You see, when you cry for the chick, you must also think about the hawk. Was the CJ of the view that, oh, this one, it won't hurt me, so I shouldn't cry about it? Similar petition for your removal. No, there was no cry, there was no action, no public comment. But he was acted upon using the same Article 146 process. Now, another petition has come asking that it should be removed from office. The same process is being triggered. And suddenly, the whole world must come to an end. So I have a problem about her conduct in this matter. Because she thinks that now these petitions may bite her. So she must do what she's doing. I think she's abusing the court process. Oh. Please. She has handled a lot of cases. How do you say that in pursuance of a constitutional provision that matters like this, you ought to be asked to step aside? Then you make a determination that the stepping aside amounts to effective removal. You are placing your own interpretation on it. When your own court, your own colleagues makes a determination on the matter, you go to town and berate them. You berated some of us when we went to town to criticize, even when matters have been effectively determined. You think that we, even as parties, we shouldn't speak. I have a lot of cases in the court. Some have been heard, some haven't been heard. Me, when I was entering the Supreme Court, even as a party, I was searched. Is the CJ saying that when parties were entering the Supreme Court, we are not searched by policemen? I have been searched by a policewoman before, entering the Supreme Court as a party.
Touch your groin.
You understand? So she's become very petty about some of these matters. No, the Constitution says the matter must be heard in camera. Show me in the Constitution where divorce cases must be heard in camera. Not in the Constitution. But the Matrimonial Causes Act says, Parliament says, when you bring a case to court, if it's about divorce, we should go inside to the judge's chamber. Not everybody should hear it. So your children don't follow you. When you come to court, I have done cases where parents come to court with their children. When we are going to the chamber, the kids don't follow. It's only the parties. So where it's about, when the law prescribes how a thing should be done, Boyfio versus NTAC, it's only that procedure that must be followed. Some of this can be negotiated without loud talk. That, yes, I agree.
Like Martin events.
Yes, you don't do loud talk. You can say that, please, it's in camera, but you know the situation. So I want my husband to accompany me. I don't think that panel would have refused. But if you go to town, if you paint a do lodge as if it's a garrison in the Governor Barracks, where you are being tried.
Well, it's a question.
Yes.
As to whether, since the CJ's husband and her daughter are mentioned in the petition, is it not possible that they can be called in as witnesses in the pending matter? How then do we admit them in the proceedings?
Exactly my point.
Is that if she thinks she will call
if she intended,
find other people in her family.
No, so these are the issues that you can see that, yes, even though they've been referenced in the petition, you don't intend to call them. Perhaps the panel members may be pointing to that why? They are being referenced in the petition. You may want to rely on them as a witness. And that being the case, we may not be able to allow them. I'm also thinking aloud. Okay. These matters, we are not apprised of all the final facts. So the CJ should take her time. But is she assuming that should be removed willy-nilly? I think that is her mindset. Otherwise, I'll go through this matter. For all you know, I'll be exonerated.
Hey, Charlie.
No.
No.
You see, there's a presumption of innocence until proven guilty. How do you assume that one petition against you was dismissed?
This one has many charges.
No. You see, the multiplicity or the multitude nature of the charges do not constitute proof. That's the law.
Okay. Yeah.
You see, however plenty the charges are, do not constitute your liability. It must be established, and evidence must be led and recanted. You are the pinnacle. You are the arrowhead of our judiciary. Why are you in a state of trepidation?
Right.
One petition came, it failed. These ones, you must be able to have a brave face and deal with the issues.
Okay.
If I were her. But this pension of running to the media, using different lawyers, and filing all sorts of process, you are in the High Court, you are in the Supreme Court. I'm sure even if the rules permit her, she would have gone to the Court of Appeal. Now you are in before Echoas Court. Okay. No, she's doing what we call forum shopping. Senior, let's be. Look, she's doing forum shopping.
Let's not kick her. She's already.
She taught us law. When you go to court, she will put you right. She taught us law.
We don't need to kick her more.
At the bar, she's doing forum shopping.
Nelson Robson,
and I think she should stop it.
And
let's go through this matter.
Now,
she may not be guilty after all.
Okay.
She's painting herself that she's guilty before charged.
Right. So live here on Key Point. We're live on 3FM 92.7. Now, I'm going to go for this quick break. When we're back, you want to know what the state of the presidential jet is? No, stay with us, because yesterday, no, respectfully, we'll speak. After this quick break, the defense minister was in parliament yesterday. We'll play back some of the things he said, and it gives a rather worrying, grim picture of what the state of the presidential jet is. Stay with us. We'll be back shortly. How do you see this case playing out from where you said? What outcome do you expect of this case, taking into consideration all you have just said at the Echoas Court?
One of those, cases, I think, that be a return match. They will ask her, they'll bounce her to come back to Ghana. I don't see how the Echoas Court can change our rules of procedure. Our rules of procedure are, firmly embedded in the High Court rules, with the support of, the Evidence Act of 1975 and RCD 323. They are there. It is a procedure for, Ghana. It is not the procedure for ECOWAS. It's for Ghana. And ECOWAS doesn't have, a West African sub-regional procedure that we are applying and violating. It is our own rules of procedure and evidence that we are applying. And therefore, taking the matter out of the purview of our court to the ECOWAS court is not going to achieve the desired, purpose. I think it will be defeated. And at the end of the day, I think that upon a sober reflection, the Chief Justice will realize that, she has shot herself wrongly in the foot. No one else. She's making her bed and she's lying in it. And it saddens and pains me that, she's adding more insult to injury. I've said elsewhere that.
Right. And that point that you made, and that's where Mr. Konkwas are bringing. So, Kpebu, that's some detail to the position that he took, that ECOWAS court cannot necessarily change the rules of engagement, essentially, if you look at it. But then again, he still holds the view that there are a number of applications regarding this matter. And you see the Deputy Attorney General reference it as well, that some of the issues he's seeking as relief in this application are also being tried already here.
Yeah.
So why not wait for the outcome before going?
Yes, so as we said, the Echoas court is saying they can also look at it. And don't forget that, you see, in law, as we, in human nature, we are different. Some people are conservatives, others are liberal, some are in between, etc. We should bring the psychologists. I keep saying that that's one area we don't pay attention to. Sometimes we just see human beings and we think everybody is good or everybody is bad. No, but there are differences. So in the same way, in law, there are various philosophies. So you hear the textualist approach, the purposive approach to interpreting statute, constitutions, etc. Right? Yeah, so to that extent, a case that you may see as bad here, it's possible in the other forum, they may see it as good. You say, so I don't want to say anything about the substance of her case. No. As I've said, she's struggling already, right? I mean, the torture, okay? The torture is a lot. And you see that's how come I've repeated here several times that if I had my way, I would have seen if we could have mediators come in and see how she can be allowed to exit with a resignation. Because now you see where we've been taken to Echoas court. So those things have been published with the Echoas court. Who knows, from Echoas court, maybe she'll go to the African court. We don't know where else. So by the time we are done, all of us would have been fully dragged in. So sometimes, I mean, if you give the person an exit, for me, what is clear is that once it's an exit to go, fine.
Okay.
But not an exit that come back, no.
Right.
No, that one I'm very, very clear that no. These are very serious matters. Either we go into the details and get merits, or she should be given an opportunity to leave, but not the one that come back and occupy the position without us going into the case. As for that one, if she wants to come back into office, then let's go into the case.
Okay.
Okay, because those are very serious matters. We can't sweep those under the carpet. Otherwise, democracy will not grow. So that let's be very clear.
Indeed.
So let's see how we can do, because now it's becoming just one too many. Today we are in this court. The next day we are in another court, and the publications, it's dragging us. It's dragging us. I don't think that it helps us. Yes, somebody say, well, maybe it's generally a taboo conversation. Perhaps if we don't get a political settlement to it, and she continues, by the time we are done, okay, we will now in future discuss these matters without feeling squeamish about them, right? They will no longer be taboos. They will no longer be a Pandora's box. Okay, that's also another thing. But if we can resolve this quickly, that will be better so that we get closure.
Thank you very much. Lana should have never involved on this. I don't intend to spend.
Yes, let me. You see, this CJ matter. I think my brothers have spoken, but let me bring this perspective. There was a petition.
I beg you. I want a question answered.
Okay.
Before you go on. Otherwise, Martin Kpebu, you have given him a question to answer and he spent time talking about other things. You were asking whether the CJ had said that by her suspension, she had been virtually sacked. Effectively sacked. Okay. And then I was thinking you wanted Martin to speak to it, whether that is true or not. That is very important. Whether she can remain as a Chief Justice to oversee her own trial. But that's what he has said.
He said that she's not coming back.
No, he said that in the last part of the conversation.
Unless she wins the case. No, she can't come back.
Can she be the Chief Justice? Because you said that by her suspension.
He answered that in a form.
So don't worry, let's repeat to be clearer. What I'm saying is that if we can get a settlement that she should resign, exit, go. Okay. Yes, I'm in support of that so that we can reduce the litigation because it's embarrassing us, right? But if she's not willing to take a resignation, it wants to be led back to act to continue as Chief Justice. No, that one is not possible.
Thank you.
It's not possible.
Yes. So let me say this. Sometime last year, late last year, Professor Azar brought a petition for the removal of the CJ. That petition was acted upon and determined. What did the president do? The president made a prima facie determination. President Nana Akuffo made a prima facie determination on the petition, and on the 6th day of January this year, not last year, just this year, this 2025, one of his last acts in office as the head of state of this country, actioned that petition and said it was unmeritorious. So let's bring this matter into perspective. The suspended CJ, as she is now, never applied for a copy of that petition. Not to my knowledge. She didn't go public about it. She didn't file any process. She didn't say that she needed to be heard before the president made the prima facie determination. So let me ask, was she aware that the prima facie determination will favor her? You see, we when you cry for the chick, you must also think about the hawk.
And we and some of the course or channels who mamma was so yemre how a GH Politics Avenue. That's an somebody in Yadum Yadum Yan, yes, and Shemwing, not in some all consum supra, but as I saw yemre.